okay? Okay, well, welcome to the Happy Hour training by On Point TC. My name is Alex. I'm not an attorney or an accountant, but I do like to share my knowledge about certain things. I've been lucky enough to be able to use PowerPoint and I think pretty proficiently and kind of get the point across using these presentations. Let me fix my screen here real quick. I don't know how this happened, but so anyway, so that said, thank you for joining me. Today is September 29th, roughly about 6 o'clock, and let's go and get started. So as always, this is my information. You guys are welcome to call me, email me, or take a look at my website. I have been doing some maintenance on the website, so you'll find that the website might be going up to something else here in the next couple of days, but it should be back up fairly shortly. And oh, there we go. I think I fixed it. Oh no, I didn't. So kind of getting sidetracked there a bit. So anyway, you guys are always muted. Thank you for doing that. Thank you for actually coming on early. You're welcome to question or comment in the chat room. I'll try to get to each one. And unfortunately, I think they're having a party here next door to the office. So I have the window closed, but you might hear some of the music bleeding through. So I apologize. Hopefully it's not too much of a distraction. Again, thank you guys for logging in early. And as always, feel free to share the meeting ID and we're not password protected, but the meeting ID, as anybody's invited, licensed or not, they want the information. So thanks for coming, guys. And like I said, I did start early today, mainly because there is 28 slides to this presentation. So I'm gonna hope to go through it fairly quickly. However, there is a lot of reading. So, so bear with me, okay? You guys can follow along. So to understand what a purchase agreement is, one must first understand what it is we do as licensed agents. The presentation, or this presentation, has been separated into 6 parts designed for separate day training. Part 1, recap some of the same forms that were covered in the listing agreement presentation. Training will recap here again, and you'll see it's mainly because some of the same agency agreements and some of the disclosure that we have to give to our clients are the same, whether they're buyer and seller. So we're going to recap some of that stuff. Okay, so this is some of that information, right? The agency disclosure, the possible representation of more than one buyer and seller. We have the wirefighter advisory, the buyer's inspection advisory, the trust advisory, real estate owner advisory, which we don't see too much of, mainly because we're not in a foreclosure climate at current. And that goes along with also the short sale addendum, right? Which we're fairly new some years back, and that's when I originally had made this presentation, and the California Consumer Privacy Act advisory. And there is one missing here, which has hit the forefront here probably in the past year, and it's the fair housing. So just so you know, the reason why I wanted to start doing this presentation, because it's in 6 parts. So we won't actually be getting done with it till the beginning of November, because it'll take us that long to get through it. It's because the form is going to change in December of this year. The RPA is going to change. I'm not sure what the changes are going to be. I haven't gotten to that point yet in terms of being able to read some of that stuff. The information is already available in terms of what's out there. But what I wanted to do was at least get this on the books, and I know you guys are most of you guys are regulars, in terms of understanding what we're dealing with now. So then when we see the changes, we might understand them a little better. So that's the reason why I thought it would be a good idea to go through these and not skip it all together, have them recorded, have them in the channel, and have them as a reference to be able to go back and look at to what used to be, and then we can look at the new stuff and potentially address things. Because just because these things are written the way that they are doesn't mean you can't change them. It's just the art of negotiating. It's the art of negotiating the contracts, right? And so that said, oh, there it goes. It's working now. That said, that's the reason why I'm doing the current residential purchase agreement. And you'll see throughout the presentation that what it's really called is a letter of intent. And that's because you don't have to use the residential purchase agreement that CAR has designed, because you don't have to be licensed to buy property. So you can actually write your own contract if you want to, okay? It's called the letter of intent. So we call it a residential purchase agreement because that's what CAR attorneys have called their compilation, right? That's what they've called it. So that's what we'll be going over, because the majority of us are using it, right? Any questions or comments on that? And I'll make it a little more clear as to what I'm talking about coming up here, but let's get started with the AD, okay? So agency definition, right? A business organization established to provide a particular service, and sorry, so there's some folks here logging in, typically one that involves organizing transactions between two other parties. So you're organizing a transaction between two parties, right? Despite what is popular conversation in the real estate business, real estate agents or realtors do not buy or sell real estate. That is, if it is not their property. So make sense of that for a second. Real estate agents do not buy or sell property, because that's what people will generally just say. Oh, you buy and sell property? No, unless I'm an investor, no, I don't buy and sell property. I facilitate. So real estate agents facilitate transactions. There's a disclosure that covers this precisely. It's called the AD, or disclosure regarding real estate agency relationship. Representing a buyer begins with agency relationship and leads into the purchase proposal, otherwise known as letter of intent. The RPA, residential purchase agreement, has been designed to cover the price, terms, and conditions associated with the agent representation known as agency. So just to be clear, right? And there's that letter of intent again. That's really what a purchase agreement is a letter of intent. It just happens to be written by CAR attorneys and happens to be, I guess you could call it trademarked or copywritten, because you can't use what CAR has designed. And believe me, there's been lawsuits to try and get it away from them, but they typically will not release that to anyone else. So you're, by joining a board and having use under ZIP forms, you have exclusive use of these forms, but only under the agency that you're working for, right? So you have to be a broker to be able to use these forms, okay? But in terms of how to use them now, it is a letter of intent. And the first thing that we do as agents is we establish agency, which is simply facilitating a buyer and seller, or facilitating those two parties. Any questions or comments on that? All right, so let's keep moving. So the AD, and the majority of you have seen this, and so you know that I break these forms down and on this presentation, so you're not looking at the full form. But the other thing that has changed since I made this presentation is that the AD1 and the AD2 no longer exist, okay, the way that they used to exist, okay? They used to be two separate forms, and you'll see here that I'm going to go through these highlights here real quick just so I can show you. You'll see here that on the top of each form, and I snipped two different ones, right? That one of them says seller and the other one says buyer. Now, so that doesn't exist anymore, okay? And you'll see this form was revised in December of 2018, And I want to say the new ones probably came out probably early 2020. And I could be wrong about that, but they are now just one form. But now what they do is they have a section where they sign where it just says buyer seller. Okay. So before, the idea is that when you're dealing with the seller, you are disclosing to the client what your responsibilities are. And you'll see here highlighted now on the actual form, which is now simply just a repeat on the 82. And so that's why they kind of made it just now one form. Okay. So if you're dealing with the seller, you have the seller sign it, you just mark seller. If you're dealing with the buyer, you mark buyer, and the signatures are the same, but it pretty much says the same thing. And there is a seller section that's identical. Okay. And you'll see there highlighted, agreed to act as agent for the buyer only, right? So that exists on the AD now. And then highlighted again, a fiduciary duty to utmost care, integrity, honesty, and loyalty in dealings with the buyer. Doesn't say anything about buying real estate, making decisions, doing any of that stuff, right? Agents don't do that. Agents do not select price or pick a property or do any of that stuff, right? We're simply facilitating the transaction. And there are statutory duties, right? And those statutory duties we should be performing under the utmost care of integrity, honesty, and loyalty. So that's what it's talking about. So really, us as agents, that's what we do. That's what we're supposed to do, right? But here's where it gets a little sticky, and this is why I highlighted section C, okay? A duty to disclose all facts known to the agent materially affecting the value or desirability of the property. So me as an agent, I have a duty to disclose all facts known to the agent. It's that simple. And I've gotten into conversations many times with agents that say, oh, no, I don't have to give you that. I don't have to tell you that. And then when I show them this, they say, oh, I've never seen that before. It's like, well, this is your responsibility, Mr. Agent. This is why you're licensed, because you are supposed to disclose all material facts. Now, let's not get confused where material facts are involved, okay, with confidential information. And that's the last line there. An agent is not obligated to reveal to either party any confidential information. Who can give me an example of confidential information that we're not supposed to be giving out? Anybody? Well, I'll give you a quick example because there is a section on one of the forms called seller affidavit where it asks for the social security number of the client. We absolutely never, ever give out a social security number to a client. And the form itself even says it in bold type. Do not give out this information. Okay, so there's just that one thing. And I'm not just saying that social security is the only confidential information. No, I'm talking about confidential information as a whole. We do not give out confidential information ever, because we would be now breaking that integrity and honesty and loyalty that we're actually signing up for. So understand that disclosure has to do with, if we're dealing with a seller and the seller happens to know that there's something wrong with the septic tank, and I have a report stating that, but the seller's telling me not to give it to the buyer. Guess what? I'm now violating the trust that I have now signed up for here on the buyer's and agency agreement. So the agency disclosure, although named the same, AD, comes in two different formats. So just know that because this is an older presentation, it's only just one now, even though you're going to have two. You're going to have one from the buyer and then one from the seller in your file. And you should always ask for it, mainly because it has this verbiage. Understand that this is a little different than the agency confirmation, which is on the actual contract itself. You know, most of us are familiar with the purchase contract, and on page 1, it has a section where it talks about who the selling agent is and who the listing agent is and who they're representing. So that's an agency confirmation. That's a little different than the agency relationship, okay? And mainly because that agency confirmation doesn't have this verbiage. And what do I always say? It's not what you know, it's what you can prove. So if you have this, okay, and an agent is saying to you, oh no, I don't have to give you that, right? All I have to do is show this to them and say, yeah, you do. You have to show me all facts known to the agent. It says it right there. And you signed it, sir. 99.9% of the time, they're coughing it up, believe me, because they've never read this and they don't understand it. But going into this, we now understand that real estate agents don't buy and sell property. We're simply facilitating the transaction in terms of utmost care, integrity, honesty, and loyalty in dealing with your client. That makes sense? Questions, comments before we move on? And again, remember that this is only just one form now. It's just the AD. So it's not. It used to be the 81, 82, but it's just the AD. But now it is what's it called when you do right or left? I don't remember the word, but I was going to say, oh, is it ambidextrous? No, I don't remember. But that said, let's move on. Questions, comments on the last one? No. So here's the section I was talking about. You'll see at the bottom it says AD, and then you see the section here. Good night. You see the section here where it says buyer, seller, landlord, or tenant. So this form can be used for any of those individuals. And as always, be sure to date, which I think it actually will say it here now at the bottom. It's important to notice that this form can be used for buyers and sellers and tenants or landlords. And signatures can be obtained digitally and manually along with the date. Don't forget the date, guys. It's remember that not having the date makes it where it's not executed. Whenever sign anything, please do not forget the date. The same form is used for both buyer and seller. We need one for both listing and selling agent. Any questions or comments on that? So this is the bottom of the AD, what we were looking at earlier. There's two sections actually. So it says seller and buyer on the last slide. So that would just the one form. So this is typically when you pull up the RPA CA on the zip form CAR website. This is going to be the first form that pops up in that packet of forms, and I want to say there's 18 or 19 forms, I think, something like that, 18 or 19 pages. So this is the first form that pops up. So the agency agreement, and even when you take a listing, same thing. So this is page 2 of the same, right? Page 2 it covers civil codes, and this is the reason for it. The form is because it's statutory, meaning that it's required by law. Okay, and this is simply just an example. So there's a sample section that is usually found on the agency confirmation and the residential purchase agreement that does not need to be signed on this form. So this page 2 doesn't need to be signed. It's simply just an example, and it shows the example, but mainly it actually points out what the law is for this disclosure itself, so that there's a sample there. That's the sample what you see on the purchase agreement. So any questions or comments on that? All right, so moving right along. Oh, so quickly, let's do a funny. We want a cozy, secluded 20-acre farm surrounded by hills, trees, and streams within walking distance of shops, restaurants, schools, theaters, and hot night spots. Night spot. So this is funny because you have all the expectations of a buyer, and then slowly but surely they get brought back down to earth as to what's really available, and then they have to settle, right? So that's pretty funny when you're dealing with clients. Okay, so let's move on to the PRBS. And you know me, guys, I'm always using the acronyms. PRBS stands for possible representation of more than one buyer or seller, and it's a little bit easier to use the acronym than say that whole mouthful of stuff that they decided to put on these forms. So this is the reason why I use the acronym. So I recommend trying to learn them. I mean, as you go through any files, you start to learn them little by little. It's just not something that I would say don't sit there and study it, right? But for the most part, the more often you use it, the more comfortable you become using the acronyms. Not to mention the fact that it makes it easier to find these forms when you realize that you need them on a one-off basis on the zip forms system, right? So the AD is the consent to the client of the agent's duties. The PRBS is a disclosure of how these duties can differ and what they entail. Okay, so so the nice thing about what we're talking about today, because I mentioned the purchase agreement is going to change in December of this year, okay, is that I really do feel that the majority of these forms will not. And so all of today's presentations, or this presentation, most of these forms are not going to change. And this one came out November of 2014, and we haven't seen a change since, and it's mainly because it spells it out. So there's the broker, right? Real estate broker, whether corporation, partnership, yada, yada, yada. This multiple representation can occur through an individual licensed or broker salesperson, or through different individual brokers or salesperson or associate licensee. So understand that when you have a real estate license, you actually have to hang your hat with the broker, because the broker is actually the one that is licensed to be able to handle a client. You by yourself as a licensed agent are not. So understand that you have to, first of all, you have to hang your hat with a broker, and you also have to be a member of a board, right? So the associate licensee may be working out of the same or different office locations. So what we're doing here is we're advising the client of this. We're pretty much telling them that a broker exists, and I may be a licensee, but we may be working out of separate offices. So these are things that we can't just assume, or a client can't just assume. So guess what? They came up with this disclosure or advisory, pretty much letting them know that these things exist. This is how things operate, because they may not know anything about real estate, but they want to buy a house. It's common, you know, to have that situation. So now we're dealing with multiple buyers, right? So broker will not limit or restrict any particular buyer from making an offer on a particular property, whether or not broker represents other buyers interested in the same property. So you're pretty much telling your client, hey, if I come across another buyer that's interested in the same property that you are, I can represent them as well. So you're pretty much disclosing that to your client. You're pretty much telling them up front that there could be competition and there could be conflict. And most of us would think, oh no, you can't do that. But what it's saying here is you can do that. It's something that you can do, right? So any questions or comments on the first section of the PRBS? So it kind of goes along with the title, possible representation of more than one buyer or seller. In other words, if you have a buyer, you can potentially represent more than one. You can have three on the same property. And that's pretty much what you're telling your client with this disclosure. And I'm sure there was some kind of lawsuit or something that came about, and they decided at some point that, you know, that an agent can do that. Why can't they, right? Some buyers and sellers may not like it, but it's just how it is. So now on the seller side, right, multiple sellers, right, the broker may have listings on many properties at the same time, right? Broker will attempt to find buyers for each of these listed properties, and isn't that what they're supposed to be doing, right? Broker will market all listed properties to all prospective buyers, right? Of course. So you could potentially have a buyer and also a seller, and you could potentially market that property to that buyer, and you're pretty much telling the seller, hey, Mr. Seller, you know, I have buyers too, and I'm telling you that I can bring them to you, but that buyer doesn't necessarily have to buy your house if they don't like it. So don't get mad, Mr. Seller, if they don't buy your property just because I'm representing them. They may end up buying another piece of property, right? So it says it there. Some properties may attract more prospective buyers than others. So it just boils down really to those factors. And can a seller get a little angry at you because, oh, how come your buyer didn't want to buy my property? It's like, Well, I guess they could, but the fact of the matter is you can't force anybody to write an offer on a property. They may not like it, may not meet their needs, right? Now we get into the part where an agent now can represent both buyer and seller, right? So seller acknowledges that broker may represent prospective buyers of seller's property and consents to brokers acting as dual agent for both seller and buyer in that transaction. So, sorry, I thought there was more to that slide. Is there any questions or comments on that? So most of us understand that when we're working with buyers, that you can have potentially more than one buyer that you're working with and sellers, right? And the same thing, you know what? You might have 5 listings and 2 buyers, and your buyers end up buying properties that end up not even being your listings. And could that make your sellers a little upset? Possibly, but you're warning them up front that, hey, understand that I can't force them to buy your property, but you're kind of telling them up front. The other thing you're telling them up front, the sellers and the buyers, is that you could potentially represent them on both ends. So that for most of us, that's a good day, right? So anyway, any questions or comments on that slide? All right, so moving right along. So this is the part now when it comes to confidentiality, and kind of important now because I want to say that this section here touches on the one thing that most agents do on a daily basis that they shouldn't be, okay? So in the event of dual agency, seller and buyer agree that broker without the prior written consent of the buyer will not disclose to the seller the buyer is willing to pay a price greater than the offered price. So just as a rule of thumb, guys, you never talk about price to the other side, especially if you're dual agent. Even if you're not dual agent, if you are dealing with another agent, you shouldn't be talking about price. Hey, what's your seller willing to go to on this, right? Not supposed to be doing it. It's considered confidential. Will not disclose to the seller that the buyer is willing to pay a price greater than the offered price. Same thing goes for the seller, right? Will not disclose to the buyer that the seller is willing to sell property at a price less than list price. So, excuse me, a dual agent is obligated to disclose known facts, material affected. So we already talked about that, value or desirability. So that's there it is again, it's same as the agency disclosure, talking about that. But the main part of this particular section is that we're not supposed to be discussing price, okay? Especially as dual agent, because when you're dual agent, now you're talking to both buyer and seller, and it's just not something you're supposed to be talking about. So most people have asked me on this section, so Alex, so then how do you discuss price? Hey guys, put it in writing. How do you discuss price? Make an offer. It's called the letter of intent. That's what you do. You make an offer, right? And that's, now you're discussing price, but guess what? You're not doing it. It's the buyer or the seller. It's them now. And what are we trying to do? We're trying to facilitate them. Remember we talked about that at the beginning when we talked about the agency, is that we're simply facilitating them getting together. It's called meeting of the minds. Does that make sense? So we're not supposed to verbally be discussing price. Let's put it in writing. Now, some will say, well, Alex, you know what? Yeah, that's okay. You know what? Everybody does it. You know, just understand, folks, that when you're dealing with dual agency, it would be easier for them to nab you for something like this. Okay. So just remember who you're advocating for. Okay, you're advocating for your client. So I would just make it a common practice just to keep the price hush. Hey, look it, do the best you can. This is what I always tell the other side. Do the best you can. Put it in writing. Put it on an offer, and I'll submit it. And I'll see what I can do. That's usually what I tell them. A little patronizing, yes, but at the end of the day, I didn't discuss price. So just understand that that's what you're disclosing to your client, but you're also signing this. The Prbs has signatures for buyer, seller, and both agents. Interesting concept on this particular form, right? So confidentiality offers not necessarily confidential, right? And this is interesting too. Okay. Buyers advise the seller or listing agent may disclose the existence, terms, or conditions of buyer's offer unless all parties on their agent have signed a written confidentiality agreement, which I've never seen before. In my 32 years of doing real estate, never seen a confidentiality agreement where you take a listing and the seller tells you, I do not want you sharing information. As a matter of fact, it's on the RLA 10, it's section 10. A3, if I remember correctly. 10A3. It used to be 7A3, but it's 10A3 because the listing agreement changed. But here's the thing. When you're talking to you have a buyer and you're talking to a listing agent, and you ask the listing agent, hey, how many offers do you have? They say, oh, I got 20 offers. And you ask them, well, what's your highest offer? And they tell you, oh, I can't tell you that. That's confidential. But what does it say? This is headed confidentiality. And it says buyers advise and that the seller or listing agent may disclose the existence, terms, or conditions of a buyer's offer. It says exactly the opposite. So why are they saying it's confidential? It's because the listing agent doesn't want you to know what the highest offer is, because that highest offer may very well be from them, so they can represent dual agent for buyer and seller. They make double the commissions. That's why they don't want to tell you. Well, would any of us consider that to be a violation? I know I would. It's a violation of honesty that we talked about at the beginning under the agency disclosure, right? The agency relationship. Because now the agent's looking out for themselves. They're not looking out for their client. So it says the opposite. The listing agent can disclose to anybody unless they have a confidentiality agreement, right? Any offers that they've received. Hey guys, think about that for a second. Why wouldn't you want to post that? Why wouldn't you want to post that? Don't you want the best price for your client? If you're able to if you're able to tell somebody tells you, oh yeah, I got an offer for 480, and then the next guy's going to come in at 485, and then the next guy after that's going to come in at 490. It's just going to keep going up. It's called a bidding war. But why wouldn't you want that situation? You want that situation because you want somebody to remove the appraisal contingency and say, oh yeah, you know what? I want this house so much that I'm willing to pay this much. I'm willing to pay 500 for it. Why wouldn't you want to do that? That would be the best for your client. You're representing your client. Now, hey guys, you know, I'm tooting the horn here of the forms. And you know that this stuff goes on in the background. So I'm simply showing you what is right, and what you're going to do will reveal itself at the end of the day. So I'm not here preaching to you, okay? I'm simply telling you how it is or how it's supposed to be, and you know, take it with a grain of salt. So okay, we got a comment. Most of the time, most time it is used in witness protection, also people like cops or other agencies. So, okay, well, I guess it could be. So that side of it, any other questions or comments on this? So we're not doing too bad. 6:34, we're slide 11, so we're not doing too bad. And some of the presentation actually goes pretty quickly. Questions, comments? I had to wet my whistle there for a second. So let's keep moving. So acknowledgement and consent. So here, the part I was telling you that everybody signs it, buyer, seller sign it, if there's multiple buyers, multiple sellers, and then each firm, the selling firm and then the listing firm. And it is simply consent by all parties that that everybody understands that this is how the business of real estate is run in California. I'm not sure about other states. I'm not sure what the laws are in other states. I only know California. So this PRBS, again, it came out in 2014. But I would say that most people just never took the time to actually read it and understand what it means. I think most people just sign it because it comes in the packet, and then they sign it and say, oh yeah, okay. They read the header, possible representation, more than one buyer or seller, and they say, okay, I kind of understand, right? But you guys just got an infusion of what it really means, right? And again, don't forget to date That's like the most important thing. That's the one thing that I find mostly to be deficient on most forms, right? So disclosure and consent agrees to the agency possibilities disclosed. So it's calling it an agreement. So in other words, when you get your client to sign this, they're agreeing to the fact that they understand that these things are possible. I can represent more than one buyer. I can represent more than one seller. And even though you may not be related to those individuals in a transaction, I can have dual agency. I can share your offer with other potential buyers, right? To get the best for my client. So it's telling them that up front. So any questions or comments on that? Names and companies have been added to this form to illustrate complete signature. Please do not forget to date. So actually, I didn't add those things. I don't know why that says that. I didn't review it good enough this afternoon, right? I went over this afternoon, and apparently I didn't see it close. So let's do some questions. Why is it important for buyers and sellers to consent to this disclosure? So I kind of already said that, but it is important because these are conversations that a lot of times when you're sitting down with your client, let's say over a cup of coffee or maybe during lunch, when they initially present themselves to you and they say, hey, you know what, I'm interested in buying a house. Okay, well, you know what, why don't we have some lunch and let's talk about it. Let's have a cup of coffee. These are the kinds of conversations that you don't have with the client, right? Instead, the conversation is more about where do you want to live, what's your budget, what kind of down payment do you have. Maybe not in that order or at that quickly, but for the most part, those are the things that you're trying to get to when you're initially meeting the client. You're not talking to them about dual agency and possibly having other, actually the topics that are talked about in the PRBS are fairly uncomfortable topics. So it's best to just say, oh, here, just sign this, and then let's not talk about it ever again, right? The idea is that they don't even really know that this exists because nobody really talks to them about it. But you as an agent now, again, take it with a grain of salt. You might want to just briefly comment about it, that this stuff exists, and move on. So how can the presumed rules of this disclosure affect your practice and business? And I kind of just mentioned that it's fairly uncomfortable. It's fairly uncomfortable for a lot of people to have those discussions. And it's mainly because these are now legalities, right? These are things that we're dealing with now in legal nature that understanding it, because it's on this form that somewhere it's written, somewhere it's some kind of civil code that this is allowable behavior. And so brokers are now, being advisory to their clients and consenting with them and disclosing to them this information because this is how the business is run, right? So is it also important for agents and brokers to read and understand this disclosure? And I would always say yes. Hey guys, do yourself a favor next time you get a chance. And I certainly don't mean to do it all in one day, but one day pick up the AD, or 1 week pick up the AD, read the first page. It'd probably take you, I don't know, let's say 7 minutes to read it. The following week, pick up the PRBS, read it, take you another 7 minutes. Not a big deal, but the important thing here is that once you read it, it's almost like your comprehension. Yes, of course, you have to comprehend what you're reading, but for the most part, seeing it here, because I'm taking it out in snips, it's a little bit harder to understand as a whole. But when you read the whole thing, it actually makes a little bit more sense. For purposes of the presentation, I actually took it apart because I'm tearing it apart and I'm actually focusing on section per section. So one could say that now it's all just one big blur. So this is where I'm saying, do yourself a favor, pick out that page of a contract sometime, and some of us have them in older files, and just read it. Take you 7 minutes, if that, okay? And then it'll kind of click, because that's what happened to me. So I'm not saying that that's what's gonna happen to you, but That's what happened to me. It clicked when I was able to read it and tear it apart, putting those two things together. It started to make sense. So any questions or comments on that? All right. So I'm taking you guys are catching all this, right? So no questions or comments. I'm assuming everybody's good, right? Don't fall asleep on me now, or some of you guys are probably eating dinner. I get it. So I'm gonna wet my whistle here, guys. Do a lot of talking. As always, you guys know that I do not like to do a monologue. I like to do a dialogue. So feel free to chime in anytime if you guys have just any little thing that pops in your head. I know there's a lot of that because when I'm sitting here doing watching a presentation, I got a lot of questions that come up. So that's just me, I guess. So let me find the move forward page here. So let's do the wire fraud and electronic funds advisory. Okay. So this one will be fairly quick. This form has been provided because of hackers and scammers, right? They take the opportunity to take on this criminal activity. And I personally know of an escrow company that got ripped off for like $50,000. The escrow company had to replace it, and it's because they got hacked. And so this activity does exist and is very real. So understand that this is the reason why this particular advisory came out in 2017. So this is just a baby, but for the most part was happening before that. And this is one of the main reasons why the CFPB came about. So Consumer Financial, Consumer Financial Protection Bureau, that's what it is, CFPB. So we all need to exercise extreme caution. So, there's some protocols when you're dealing with an escrow company, and they will tell you, here's the wire instructions, but you need to call and make sure that you're talking to the escrow person that you're supposed to be talking to, and then they'll give you enough information so where your wire's safely transferred. And this gives you the protocols to do that, right? And it says it right here. You are advised, right? Obtain phone numbers and account numbers only from escrow officers, right? Do not ever wire or electronically transfer prior to calling to confirm the transfer instructions, right? Orally confirm the transfer instruction is legitimate. So in other words, you're going to call them and say, okay, so I'm supposed to send it to, and then you're giving them the account information, right? Avoid sending personal information in email or text. So that's actually how they hack you, because you're sending this stuff electronically and it's being grabbed by someone else, right? And oops, sorry, I went too far here. And so here is the bottom of that same page. So if for whatever reason you feel that there's some suspicious activity, this advisory is giving the information on who to contact, right? So immediately notify your bank and other party, meaning the escrow office, right? And then you can contact the FBI, you can contact National White Collar Crime Center, and you can contact the On Guard Online, right? These are entities now that are designed to try and ward against this kind of hacking of wire fraud. So we're pretty much advising our clients. Okay, we're advising our clients that this activity, number one, it exists, and number two, the protocols on what to do to try and ward against it. But if it happens to happen to you, God forbid, this is the way that you potentially can handle it. So it's giving you those three different levels of information. And again, don't forget to date the form. Obviously, they're signing it, buyer and seller signing it, to understand that these are the protocols when using or wiring money. Because there's always that option of putting the earnest money deposit and also the closing funds in the form of a cashier's check from a bank. It's always the option, right? And it's old school, but it still works. And definitely a step away from the wire fraud that could happen if that's the case. And there are some folks that are wiring $300,000, $400,000, and that's pretty scary. You imagine that it just disappears, right? It's happened once here in this office, but it turns out it was just one digit off, so the money got lost, but it got found again, so it wasn't hacked. So anyway, any questions or comments on that? Man, they got the door open over here. It's like loud. Hope it's not too loud on your end. Any questions or comments on wire fraud? Okay, so let's move on to the BIA, or the Buyer's Inspection Advisory. So this is now telling a buyer, okay, Mr. Buyer, these are your rights to physically inspect the property, and it's giving them the different options. So you can physically inspect the condition of the land and improvements being purchased. It is not guaranteed by each seller or the broker, right? So there's no guarantees, and it goes back to what we talked about before, caveat emptor, right? Buyer beware. And the idea of that is to have the buyer go through and inspect as much of the property as possible, right? So you have an affirmative duty to exercise reasonable care to protect yourself, including discovery of the legal, practical, and technical implications of disclosed facts, and the investigation and verification of information and the facts or that are within your diligent attention and observation. So it's pretty much telling them that anything goes, and I call it 1 to 100. You have 100 different ways that you can inspect a property, and it's telling you the importance of that, right? If the professionals recommend further investigations, right, you should contact qualified experts to conduct such investigations. So understand that even like a home inspection, it could say something about the plumbing, and it doesn't mean that the home inspector is a plumber and can necessarily give you an estimate on what it's going to cost to fix. You have to get a plumber out there at that point now to tell you that information. So that's like 2 steps of investigating. So you have an initial inspection kind of telling you what's wrong, and then a secondary inspection to tell you what it's going to cost, right? So the broker's obligations do not have expertise in all areas, and therefore cannot advise you on many items. And I would say it should say any items, but it says many, right? Brokers don't have knowledge really in anything. I'll be totally honest with you. They don't have credentials in plumbing, electricity, roofing, windows, flooring, paint, asbestos, environmental issues, wood destroying organisms, escrow stuff. I mean, the list goes on. Brokers have no knowledge in any of those things, right? So then what is their obligation? Well, their obligations are simply to facilitate your transaction, right? So one of the most misunderstood terms in real estate is the as-is clause, right? So the as-is clause does not relieve a seller from the duty to disclose all known material facts to a buyer of real property. However, an as-is clause does signal to a buyer that the seller will not be responsible for the cost of repairing any defect. Thus, whether the contract contains an as-is clause or the property is sold with certain warranties, real estate licensees should continue to encourage sellers to disclose any known facts in the property. Please be advised that the as-is clause is built into all contracts. And it's funny because I see agents all the time putting this property is being sold as is. Well, guess what? Let's not use semantics here. I understand what they're trying to say, but what they're trying to say is this property is being sold in its present condition, and the seller is not going to do any repairs. That's what they mean to say. When they say that it's being sold as is, that's already in the contract. So understand that when they're saying as is, it doesn't mean that the buyer can't request repairs, because they can. It's in the contract. So we'll get to that point, right? I think it's section 11. Any questions or comments on that? All right, so we're getting a little wordy here. So you are strongly advised to investigate the conditions and suitability of all aspects of the property, right? If you do not do so, you are acting against the advice of the broker. So in other words, this, because it's an advisory, the broker is advising the client, Mr. Client, these are all the things that you can look at and test and inspect in and around your property. And we're advising you to do so because if for some odd reason, once you close escrow and you didn't know something, guess what? It's not our fault. Well, really, that's the purpose of this advisory. The purpose of the advisory is to kind of shift the responsibility over to the buyer and say, Mr. Buyer, this is your responsibility. Because me as a broker, I'm telling you, using this advisory, that all of these things here that are on here, the general condition, the square footage, wood destroying pests, soil suitability, water and utilities, environmental hazards, earthquake and flooding, fire hazards, building permits, zoning and governmental requirements, rental property restrictions, and then lower down there's neighborhood. I'm pretty much telling them, and again, this is not a conversation that I'm having with them as I'm having coffee with them at Starbucks when I meet them. This is one of those things, again, that I have to put in writing because it's not what you know, it's what you can prove, that I told them, right? I told them all of these things. And do we have these conversations with our clients? Rarely. But guess what? This advisory just had the conversation with them because they need to sign it. That makes sense? So the general condition of the property, right? Square footage, wood destroying pests, soil suitability. We just went all over these, right? These are all things that a buyer can potentially get reports on. And a lot of this is reported, believe it or not, on the natural hazard disclosure. Some of it's reported on an appraisal. Some of it is reported on a termite inspection. Some of it is reported on a home inspection, right? So the majority of these things are actually being reported on through other forms of reports. So there are two things now that if a buyer doesn't get them, the home warranty and also the termite inspection, I'm sorry, not a home warranty, the home inspection and a termite inspection report. If they don't get those two things, we now have to go a further step and get a waiver from them stating again that they're acting against our advice because they should be at minimum getting those things because it covers a lot of these sections that can be inspected, right? Any questions or comments on that slide? So security and safety, so this is at the bottom of the form, right? And then neighborhood, area, and subdivision conditions, and this has to do with like if it's a condominium, you have CC&Rs, you have HOA documents, sometimes rules of nature. I see here the historic or governmental protection sites. Sometimes you have endangered species in certain areas, right? Some areas could be of religious overtones, if you will. And these are all things that you should inspect when you're purchasing a property, right? So we are advising our clients of this. And again, we're not talking about this in Starbucks because the majority of us don't have this conversation. But this is the advice of the broker, and you representing the broker as the agent are now talking to your clients. You might be talking about these things maybe a little more superficially, right? Because you're having the conversation of, oh, well, you know, you're thinking about moving into Hawaiian Gardens, right? And Hawaiian Gardens isn't exactly a very safe area, right? In terms of, I don't know if any of you have ever driven through Hawaiian Gardens or gotten out, maybe had a bite to eat or something. It's not necessarily the area I would take my family, in other words, right? So now you're talking about it a bit more superficially. You're not having a technical conversation about it in terms of what it's talking about here, right? So buyers are encouraged to read it carefully. So how is it that realtors are still being sued or held accountable for items mentioned in this advisory? Anybody comment on that? Because because we still hear about, some of our colleagues or comrades potentially getting sued over something that was mentioned here. Why are they blaming a broker? Well, the majority of time that I see that happen, and I haven't seen it happen too often, but I have seen it happen a few times. Whereas the reason why an attorney can actually nab an agent, even though through this advisory, they pretty much told them, hey, you guys can inspect anything you want. As a matter of fact, here's 10 different things that I suggest that you inspect under the advice of the broker. It's because what we talked about earlier, that the realtor knew about it, but didn't say anything about it. So to Dion's point here, it wasn't disclosed by the realtor. Yeah, exactly. The realtor knew about it and the seller knew about it, but the realtor didn't say anything about it. That's how an attorney gets you, because you can't just put all the blame on the buyer, because the seller has an obligation to disclose, and so does the agent. So why is it now that the seller is not responsible? Because if the seller didn't disclose it, and it's mainly, and I'll give you the main reason why I think, so this is more of an assumption, right? So take this with a grain of salt. It's because the realtor has errors and omissions insurance, and the seller may not have any money. So guess what? It's what's called the deepest pocket theory, and it's whoever has the deepest pockets and can pay for the damages that they're being sued for. So guess what? The errors and omissions insurance, if they can pay it and will pay it, guess what? That's who they're going after, the agent. And that's the reason. So why is it important to disclose everything that you know? For that reason, because they're going to come after you, even though the seller had just as much responsibility as you did. So yeah, Dion, you hit it on the head. Any other questions or comments on that? So is it wise to include this advisory with your offer to a seller? So this isn't a statutory advisory. This falls under the pillar. And so just to remind you what different pillars are, there's statutory, contractual, and civil. This would fall under the civil category of really just protecting yourself, because again, you're not necessarily going to have this conversation with the client. You are going to leave it to the disclosure to have the conversation with your client, and you're going to get him to sign it. So we have a comment. Bad experience with a realtor left a bitter experience with the buyer. I'm not sure I understand. But anyway, any other questions or comments on this, on the buyer's inspection advisory? All right, well, let's keep moving. So this is the section. We're on slide 19, coming up on 7 o'clock. So actually, we're doing pretty good time, because these here, I'm not going to go over completely. And it's mainly because we don't see them too often, but anytime you have a property in a trust, right? The trust advisory is a civil form. It's not contractual, but it is civil. And it does have some things here that actually talks about some exemptions that a seller has on disclosure. Okay, so the trust advisory will be covered in the disclosure section in a separate presentation. Trust advisory, or TA, is used when a property is owned by a trust. It includes some of the same references as the buyer's inspection advisory, or BIA, and it is 2 pages in length. It refers to various disclosures that the seller is and is not required to disclose when the property is owned by a trust. Right? So despite the trust exemption, I always recommend using all disclosures. The ESD is used in place of the TDS if the client's sentiment is to invoke their exemption. So you don't make that decision as to whether or not you want to just include the TDS anyway, because if a property is in a trust, it doesn't necessarily have to include the transfer disclosure statement. But there are two loopholes to that. So this is something that I read somewhere, and believe it or not, when I was trying to reference it the other day, I couldn't find it, but I did read it somewhere. Okay, there are two exemptions. When a property is in a trust, the general rule is that you don't have to, the administrator or the trustee does not have to disclose using the transfer disclosure statement, which is a statutory disclosure in the state of California. Okay, so instead of using the TDS, you use something called the ESD, which is the exempt seller disclosure, which is now just a single page, and it has limited questions that you're answering. Okay, very small disclosure as far as I'm concerned. But there are two reasons why an administrator will have to use a transfer disclosure statement, and that's if they were ever on chain of title. So if the trustee ever owned the property, would be one reason. So now you can't use the ESD, you have to use the TDS, or if the person ever lived in the property. So that's not always the case, okay? But for the most part, understand that just because the property's in a trust doesn't automatically mean that they don't use the TDS. Now, what I'm suggesting is that you always use the TDS, doesn't matter, okay? But it's up to the discretion of your seller, of your client. So you give them the option, you say, Mr. Client, have you ever lived on the property? No. Have you ever been on chain of title? No. So you're just a trustee and there's somebody that passed away that put you on the trust? Yes. So now they can use the ESD. So I'm telling them, okay, I recommend using the transfer disclosure statement, but if you don't want to use the transfer disclosure statement, and here's all the questions you have to answer, we can use this other one, which is your option, using the ESD, which is the exempt seller disclosure. And you can use that one, and you let them decide. But for the most part, you're simply just giving them the option. Okay, so I hope I didn't go too fast on that, but that's the trust advisory. So, okay, so Dion, ESD is used when the client wants to disclose less information. Okay, and again, it's their decision, but only if they own it in a trust. You can't use the ESD any other time. Only when it's in a trust, only when they haven't lived on the property, and only when they haven't been on chain of title. Because if they have ever lived there or have ever been on chain of title, they have to give the transfer disclosure statement. They are no longer exempt. So does everybody understand that? Any other questions or comments on that? So here's page 2 of the same. It indicates that the seller is exempt from disclosing when in a trust, right? When selling a property or refinancing a property, then the trust is not being administered, the property must be removed from the trust. So that's another issue that a lender will tell you, that they'll take it out of the trust, do the refinancing, and then put it right back in the trust. So really it's just recordings that are going on back and forth to do some financial movement with certain properties. So an administrator or trustee of a trust is not exempt from disclosure if they have ever lived on or formerly owned the property. So that is, again, something I read somewhere, and maybe the last place that I didn't look was the trust advisory, but the place I was looking was on the seller's advisory, and I was also looking on the statewide disclosure advisory, the SBSA. There's some commentary on there about it, but I couldn't find it. But I know I read it somewhere, so that's why I put it here on the presentation. So any other questions or comments on that? So should this form be used when listing or selling a property? I would say absolutely. Always use this form when the property is in a trust, regardless. So okay, so Dion, another question. If they are an administrator of a trust and was previously on title as an individual, they would need to complete the TDS. The answer would be yes. So if they were ever on chain of title and if they ever lived on the property, they are no longer exempt. So just to be clear, it's just something that, again, that I read somewhere, and I'm sure if you guys put my feet to the fire, I'll find it, because I found it once before, right? And it was just something that I read, because I do a lot of research on this stuff. If I'm going to be sharing, I'm trying to be as accurate as possible when I talk about this stuff, because I certainly don't want you guys to be making legal mistakes, right? Because I'm certainly not an attorney, so take what I say with a grain of salt. And I hope that you take what I say and investigate it yourself. You know, we talked about that last week when we were talking about putting yourself out there, right? Research it yourself, guys. That's how you become a professional. The professional that I know you guys want to be, right? Is to investigate it yourself. Look at it. Hey, you might call me up and say, hey, Alex, you know what? The information you gave us on the trust advisory was inaccurate. Guess this is what I found. Man, I love those conversations because that's what I want to know that. So if I'm telling you the wrong thing, you know, hey, let's correct it, right? But to my knowledge, everything that I've said about the trust advisory is that's what I researched and is my understanding of it. Okay. Do you have any questions or comments on that? All right. So let's move on to the Reo Advisory, which we rarely see, which we'll probably start seeing here in the next couple of years, seeing how our government is throwing us to the wolves. This might be happening sooner than later. So this form is used when properties are being sold by a lender or a reconveyance company after foreclosure. This is also a two-page form and will be discussed further in length in a separate presentation. Because the seller never lived on the property, they too are also exempt from certain required disclosures. In the event that you list or sell one of these properties, it's recommended that you include this form in the offer package during execution. So just real quick, because I'm not going to go over the form itself, okay? Do yourself a favor, at some point, read these 2 pages. And again, it'll take you 10 minutes, but read it. A lot of it is redundant. So, you know, oh yeah, we've seen this before on other forms and what have you. So you can potentially just kind of go through it fairly quickly. But for the most part, understand that because the owners of these properties probably have never even been there, okay? Never lived there, obviously, but never been there. There's certain things that they just can't say because they don't know. So this is the reason why now they're exempt from those types of disclosures, okay? And this goes on to say what those things are and are not. Some of the advisory includes explanations of the disclosures that it is exempt so that a buyer, if curious, can still seek out information involved in any required subject matter. And one of them particularly that shows up on the SPQ mainly, and it's question number 1, has anybody ever died on the property? There's no way for the bank to know that question. So if your client just happens to be curious about that, they have the right to investigate. We don't have to rely on the seller of the property, which happens to be a bank. No, we can figure that out on our own. Does that make sense? And in turn puts the seller in a position of at least mentioning any possible items of concern so as not to miss anything. So the idea, again, for the buyer in these situations to take the time, if there's any concerns, to do their own investigations, pay attention to the buyer's inspection advisory, go through that, and hey, is there anything here of concern that we should investigate? Oh, you know what, I'm kind of concerned about the pool, right? So we get a pool guy out there and we get a report from the pool guy. Turns out the pump is bad, right? Not something that we necessarily would have known otherwise, right? And the bank certainly wouldn't know. So as seen here, both buyer and seller must endorse these documents for proper acknowledgement. So moving right along, we're actually doing pretty good time. Let's move on to the short sale addendum, which again involves a third party, in this case a bank, right? So in the event that you are making an offer on a property that is listed as a notice of default or short sale, which is a slang term, this addendum can be used to address the terms and conditions that come up with these types of sales, right? It addresses when the contract begins, lender's consent, seller delivery of the property, contingency dates, lender's cost involvement, time periods. Oops, went too far, sorry. So most of these things are talked about in the main contract, but because we have a third party, we need the third party now to be in the loop, if you will, of those same terms and conditions. So now we have the short sale addendum, right? Or the SSA. Now, when you're listing a property, there's also a short sale addendum that's different than this, right? I'm trying to remember the acronym, but I don't remember off the top of my head, but it's 4 letters. But that said, when you're taking a listing that happens to be a short sale, remember to use that short sale form or disclosure, because it talks about a lot of these things. So you want to be able to address these things when you're working on a short sale, because if you don't, the questions will come up and you won't have consent from either party. Sometimes that ties things up, because sometimes maybe the seller's not willing to do certain things. They want to live there a little bit longer. You know, I've had people play their games when it comes to these issues, and it's mainly because they're not paying. They've lived there for 18 months for free, right? So what do they care? They tie things up. That means like an additional 3 months for them to be living there. Well, let me tell you, that pisses off the banks a lot of times. So it's just something to think about. So again, I'm not going to go over, you know, like I did. I didn't break these forms down because we don't see them that often, okay? But do yourself a favor and read one. You know, like I said, pick up a form a week, right? And read it. Read it a couple times. And believe it or not, you will become proficient. You don't need a college course to learn this stuff because it says it here in plain English. But ultimately, what it's doing is it's giving you the terms and conditions of what to really get your buyer and seller to agree to. So really all you're doing is you're telling, hey, Mr. Buyer, you know, you have to agree to 45-day closing on this. Are you okay with that, Mr. Seller? Yeah, okay, well, I'm gonna write it down here on the form. You guys need to endorse it, right? That's pretty much otherwise known as facilitating, right? But the forms make it easy because they've already done the thinking for you, where some of it isn't even used, right? Where you can just leave it blank. So Dion has a question. Does CAR zip forms automatically add these forms based on the listing status? No. You have to know if you're working on a short sale, if you're working on a trust, you have to know to add these things. There's something else when you're working on a trust. It's called representative capacity, or RCSD/S. So it's representative capacity disclosure. Representative, let's see, RCSD. I don't remember what the S stands for, but it's representative capacity disclosure for the seller. And pretty much what it's saying is it's revealing the person who's signing for the trust. So who's the authoritative person signing for the trust? That's what the RCSD is. So anytime you have something in probate, anytime you have somebody buying from a corporation or an LLC, you need a representative capacity. If you have somebody buying from a corporation or an LLC, you also need a representative capacity. That's the one that's RCSD B at the end for buyer, okay? But to answer your question, no, there's no way for the system to know what your listing is. So when you put the RLA-CA in on your queue, okay, on your dashboard, you have to know to add these based on who your client is. So this is where I go back, and I don't know that we've gone through this presentation when we go through the title presentation, where we go back and we locate the subject property. So the very first thing that we do when we get a client, let's say, oh yeah, okay, you want to sell your property? What's the address? So what you're going to do is you're going to go and you're gonna pull comps on it through Realist, and we did that presentation a few weeks ago. Remember when we did the appraisal, right? We locate the subject property a couple different ways. We're comping it out, so we kind of have an idea of what we could sell it for, okay? But we're also locating it in terms of the address and what have you. But what else is there? The vesting of the seller. It's telling you who the sellers are of the property, who the owners are. And there could be more than one. And if you just see names there, you can pretty much rest assured that it's not in a trust. Of course, you're going to ask them too. You're going to ask them, hey, is your property in a trust? You know, they'll probably say no. So when you can verify it, you locate the subject property, it shows up on your public record, and it shows there. Now, if it says TE at the end, it means it's in a trust. You go back to them and say, well, according to public record, it shows here that it's in a trust. Oh yeah, you know what? You're right. It is in a trust. I forgot. Well, who's the administrator? Who's the trustee? Oh, well, that was my mom. She passed away, you know, like 4 years ago from natural causes, and I'm the administrator. So now you see the mom's name on the, or sometimes it'll just say like you know, Main Family Trust. Like, let's see, their last name is Main. It's the Main Family Trust is the owner of the property, right? So now you know when you go to your zip forms to Dion's question, right? You're going to add the RLA. You're going to add the RCSD-S for representative capacity. You're going to add the TA, the trust advisory, right? Because now you have your little packet, because you know your client needs all of these things, or you need all of these things to facilitate this transaction, because they're not going to know. They're relying on you to know that stuff. Does that make sense? Same thing applies now. And let's say that the property's in a trust. You're taking a listing, so all of those things apply. You have the RLA and everything that goes along with it. You have the representative capacity, the RCSD. You have the trust advisory. But let's say the property that they haven't made a payment in 6 months and they're in foreclosure. Now you're going to add the SSA, the one you see in front of you. So now you have an additional form. So not only is the ownership creating these additional forms that you need to use, but now you have the type of sale that it is that you have to include now. Does that make sense? And again, hey guys, you guys come up with a transaction, and you're you know, this is all very fast, right? That we're talking about it. You can always call me. I literally can feed this stuff right off the hip. If you tell me, hey Alex, you know what, it's a probate, you know, oh yeah, you need letters testamentary, you need, you know, these are the forms that you need to put together. And you know what, if you read them, like I mentioned to you, took the time to simply just read them, you will know just as much as I do. I'm no rocket scientist, guys. I simply just read these things. So do yourself a favor. You'll be just as proficient as I am, right? Because once you read them, it's pretty much telling you what to do. They literally are telling you. The attorneys were smart enough not just to write it, but they're not doing it like they would their legal documents, even though these are legal documents because they're contracts, but they do it in a way that you understand, but also explaining to you and then giving you options to make changes. So you'll see on section 1A here, they say 45 days or, and then you can change it. Days after acceptance, or on what date. So they're giving, not only are they giving you the amount of days that are typical, but you can change it. So the attorneys have been smart enough to do that for us and make our business that much easier, simply understanding how to use these forms and why. I'm sharing with you the why part. Why are we using these forms, right? They make it easy with the how, okay? So any other questions or comments on that? Good questions, Dion, by the way, today. You're on point. Here's page 2. Buyer's deposit or earnest money, no assurance of lender's approval, buyer's or seller's cost. So not only is it advising them of things, but it's also it's disclosing things to them too, right? It's disclosing the fact that, hey, the lender may not approve this, so it's not a sure thing. So you have a meeting of the minds. Yes, you have the buyer and seller that have agreed to buy and sell this property, but you need a third party to agree as well. And there's a very good chance that may not happen. I have had short sale properties fall out of escrow because the lender just wouldn't do it. They ended up foreclosing on the property anyway, even though we already had it sold. It does happen. So this also requiring the buyer and seller endorsement, but because this is an addendum to the contract, it stands in addition to the RPA's price, terms, and conditions. There is an NODPA that is available for such offers. We will also be covering this addendum in depth in a separate presentation, and I do have the trust advisory and some of the other advisories that fall under the civil column, if you will, that I'll be discussing in depth. Okay, kind of like what we did today with the wirefront advisory and the Prbs and also the AD. The one forum again that I didn't talk about was the fair housing. Okay, but here I'm also mentioning the NODPA, which is notice of default purchase agreement. So it's actually including some of the terms and conditions that you see here on this addendum. So now you don't have to use this addendum if you use the NODPA. In other words, if you have the wherewithal, if you're making an offer on a short sale property, you can use that form, the NODPA, to help you with that additional verbiage. Any questions or comments on that? So here we have, this is actually fairly new. So it's December of 2019. So this is just a baby. It's not even 2 years old yet. California Consumer Privacy Act, right? This information was never really clear to either brokers or clients, and is now an extension of advisories that have been included in a disclosure packet. It provides information concerning actual personal information and media that may be public and or shared both during and after purchase of a sale of property. It lets the consumer know that they can opt out of this normal practice. So I've had people complain, hey Alex, you know what? I bought my property, but you know, I still see all the pictures of the house on Zillow. Well, this advisory is pretty much telling them that that's going to happen, right? It can and will happen because, well, the property was marketed and somebody was being paid to market the property. So this is one of the ones again that you may want to pick up and read and understand, you know, what they're trying to say here. Because again, I didn't tear this one apart. Simply want to expose you guys to these, mainly because next week we'll be talking about the actual purchase agreement. These superficial forms that go along with it have a lot to do with our facilitating the transaction for a client. And it's mainly because these are things that need to be talked about, but we rarely have these conversations with clients. So what is having the conversation with them? The form is having the conversation. And guess what? You need to sign it, sir. Right? Any questions or comments on that? So, okay, good. We're on final thoughts. So we're on slide 26, coming up 7:23, so we're actually doing pretty good time. So before I read this, allow me to wet my whistle. Give me a second. So I can read this flowingly. Even though part 1 of 6 did not even get into the residential purchase agreement, I felt it was important to cover first what is meant by agency and how we as agents use a disclosure to make that clear. How we make clear to a buyer what is required of them when purchasing a home as to what can be inspected. That's pretty much everything, right? How it can be inspected and who can inspect, whom the agent can represent and how they can represent them. And when wiring funds, what can be done to protect their investment? So yeah, you know, hey, you're wiring $400,000. I kind of would want to know that. So you know what? Probably a good idea to not just have them sign it, but kind of explain it to them kind of superficially. They may want to read the whole thing. I rarely have clients that want to read the whole thing, but occasionally I'll have a client that just wants to know what they're signing. So I can explain it to them. The ownership of financial position can also affect an offer to purchase in terms of trust, foreclosure, or short sale. When these types of ownership come up, they can be addressed thoroughly, clearly, and professionally using the addendums and advisories available by the California Association of Realtors. The forms serve the purpose of both disclosing the type of transaction they are about to embark in and also disclose any possible restrictions, exemptions, or issues that may be needed to understand the type of sale. Once that is understood by both the buyer and the agent, an appropriate offer can be made to address the issues that come up in a transaction. So the idea is not to get caught, because this has happened to me, okay? Don't get caught up in a situation where you have to now go to your client and say, you know what, we didn't address this when we started, but we should have, but I need an answer from you. And a lot of times I mentioned before, and this, again, this is what happened to me. I was the listing agent and the seller was saying, let me think about it. I was like, no, we can't do that. We don't have time to think about it. We have to address this now. And they just didn't care. They were pleading the fifth. They got an extra 3 months out of the sale, right? But the lender just didn't, they knew their games. They, to the seller, because they're not getting anything out of the sale, they're thinking to themselves, if I can get 3 more months of rent out of this because I'm living here for free, that's their position. So guess what? By using the form, I could have saved myself all of that headache because it was already thought of. And I don't remember exactly what it was. I wish I did so I can explain it, but or share it with you guys. But it held up the deal, and it ultimately ended up losing the deal because of it. And the homeowner tried to blame me because they said, oh, well, we thought you had it handled, this, and that. And it's like, well, you guys didn't want to answer this. You don't want to answer this contractually and come to an agreement. This is what happened. You can't blame that on me. But they tried to. They were upset about the whole thing. They actually thought they were going to be able to save their credit, and, all this other stuff. But again, save yourself some heartache and some headache, and use the forms that are available, because they're addressing all of the things that need to be addressed. And the more and more you do it, the more and more you'll see why you need to address those things and their importance, especially when you're dealing with short sales, because you have an unbiased third party, the lender, that is a third party to the transaction. You also have to impress, and you have to get their approval. So just something to think about. So anyway, that said, any questions or comments on that? So let's move on to affiliates and resources. So there's me. I'm a resource always. We have had some good conversations, some of you here on the Zoom today, about certain things that come up, either contractually, statutorily, or civilly, right? Those are the things that I like to address. But there's also really just a fourth pillar that most people don't even talk about. This is morally, and it talks about that on the agency disclosure, okay, about being honest, right? You're welcome, Robert Sully. You're welcome anytime. You guys are always welcome. It's my pleasure to have you guys come on and listen to me rant for an hour and a half every week. But anyway, that said, there's Mr. Larry. I think he's on the call today. Yes, he is. And there's his phone number and email address if you should have a question for Mr. Larry. He is more than happy to help. He is in the title industry, so he does can and will provide you with a title prelim and title insurance overall in your transactions. I recommend using somebody that you know, mainly because you're going to have a lot of people market to you that you don't know, and they may be just very green in the industry. I know Larry's been in the industry probably longer than me, so I do endorse Mr. Larry. He's always been a good friend and a good resource for title. Miss Liz, we don't usually see her on class here. She used to come on, some time ago when I was doing this early on, and actually live as well. But she's already been through all of my classes, and we've had our conversations about them, and I made my changes because she is a broker. She gave me some good pointers on things to change and what have you, but she's also a lender. So if you guys are in the need for a good lender, or you need a pre-approval or whatever the case is, Liz is there to help. A lot of you guys know Dave. I do endorse his product. He is a real estate coach and motivational speaker. Very, very, very effective, I might add, because like I said, I do sit in on a lot of different types of classes, if you will, whether they be motivational or educational. I like to sit in on those things so I can just kind of build myself up as well. Okay. So I always recommend that for anybody. But what Dave does is he kind of feeds in a little bit more on the side of motivation and really get you to act on what you need to do. And he'll tell you what you need to do. And he'll get on you, and you can hire him obviously as a coach, but he'll get on you on what it is that you need to do to actually get it done. And then when you start seeing results, that's really when the courage kind of kicks in, because yeah, we're all kind of a little fearful. I know I am, of getting out there talking to people. It's easier for me now after doing it for so many years, but for most of us, I understand. We all start off as a bit fearful, even talking about what it is that we do. Okay. Dave is very helpful in that arena. And so I do endorse his product. There's his meeting ID for Saturday in the morning and the password. So you guys are all welcome. It's free. You guys can do that on Saturday morning if you like. But like I said, I do endorse his product. Very good stuff. And then there's Shameen. She also doesn't usually come on, but she does support the show here. And so I was happy to include her in a resource for NHD products. So if you guys are ever in the market for NHD, consider Property ID, okay? That said, guys, we're at the end of our presentation. There's my information again. Next week, we'll be doing part 2 of the presentation, and we'll actually be getting into the purchase agreement. Purchase agreement is 10 pages. So the middle 4 presentations are going to break down those 10 pages, okay? Because it's 6 total, and that's because the 6th part is going to cover some other things as well. So that said, I hope you guys enjoyed this presentation. We did 28 slides in an hour. I would say an hour and a half, because I think we started at 6:03. So we're doing good time. Again, today is September 29th of 2021. I am not an attorney and or an accountant, so I always recommend that any of the information that you see here, that you research it yourself, as well as educate yourself. But like I said before, guys, if you simply just pick up the pages and read them yourself, and certainly not all at once, okay? Do one a week. Do the AD one week, do the Prbs another week, do the WFA another week. So, and believe it or not, in a month, you'll have a lot read, and you would be as proficient as me. I'm no rocket scientist, and I don't profess to be, okay? But I am glad to share this with you guys. I'm always glad to share my experiences, because if I can make your life a little easier, that's what makes me feel good. Okay, guys. So that said, any questions or comments about anything? We're just a little bit over time, but I think today's presentation was good. I know a lot of folks were asking about this. I was expecting a better turnout, but I think because we're recording it, some have just kind of said, I'll watch the recording. And believe it or not, my sister-in-law is one of them. She wanted to come on tonight, but she couldn't. And so she'll probably be watching the recording. And you're welcome, Victoria, anytime. Okay, guys, so we'll see you guys next week on part 2. And we really are going to get into the nitty-gritty of the purchase agreement next week. So bring your cup of coffee, stay awake, try to stay awake, because I'll be honest with you, when I was putting the presentation together, these 6 parts, during the middle of putting it together, I was dozing off. And it's because it's just so much information, so much to think about, so much to put together and to process. And too bad, because I remember these purchase agreements, they used to be 2 pages. When I first started, it was 1988, there were 2 pages. And now they're 10 pages, and it's because I would venture to say all of the different lawsuits and complaints and issues that have come up over the years, they just kept adding more and adding more and adding more to where we're at 10 pages now. Well, guess what? This December, who knows how many pages it's going to be? It's probably going to be 12. And who knows what changes they're going to make. but I am going to cover those things. I'm going to get into that new contract. Going to make a whole new presentation. I wanted to go over the old one, which is the one we're using now. Okay, so we can see the differences. We can see what changes were made and why, and it would make sense as to why we were doing what we were doing today, and it will make sense as to what we're going to be doing in the future. So that said, guys, unless there's anything else, I'm going to be signing off. Questions, comments? Melissa, you're welcome. Anytime. Melissa, I was actually waiting for your email or phone call, but I'm always here. So there are some days when I do leave a little bit earlier, practice, other things that come up. But for the most part, I'm usually here till 8 or 9 o'clock at night. And I like the mid shift because I find that agents sometimes work into the night. So it puts me in a position to have to kind of do the same thing. So for those of you who can hear that music, I don't know if you can hear it or not, but it's loud where I'm sitting. I hope it didn't intrude too much on the presentation. My apologies for that. I'm going to have to tell them to close that door because, believe it or not, the door is open over there. So it's making it that much louder. I noticed when they close the door, it's not as loud. But so, okay, guys, so I'll see you next week then, okay? Thank you for joining me. And I hope that this was as informative as I'd liked it to be. All right, so I'll see you guys next week.